All right, so sometime this week, legal experts believe the tax scheme trial against the Trump Organization could, in fact, come to an end. That theory coming after the prosecution rested its case faster than expected. We also know prosecutors reversed an earlier decision to call Donald Bender as one of its witnesses. He worked for years as an outside accountant for Trump and the company as well. Trump Organization lawyers sought to argue, as they put it, that Bender was responsible for not alerting executives the tax scheme was illegal. Joining us now is MSNBC legal analyst, former U.S. Attorney Barbara McQuade. Barb, as always, it is great to talk to you about this stuff. Do you feel as if, as we're kind of coming to a close on this thing, prosecutors made their case? And if, in fact, they did, right, what does that look like for a guilty, possibly former president, a guilty Trump org, and children of the former president?
Well, it's always difficult to know the way a case came out in a courtroom. You know, we can read about it, we can watch it in the media, but unless you're sitting there in the courtroom, not only hearing all the testimony and seeing all the exhibits, but observing the body language and all of those things that are necessary for assessing someone's credibility. But just reading about it, it sounds like, yes, they did make their case. What they have to show is that people who were in leadership positions knew that the law required one thing and that they did something else. In this instance, awarding all of these expensive perks to employees that they did not count as income. And so it appears that they have made that case. The defense continues, and the defense appears to be to blame the accountants for this, that, it was the accountants should have alerted the leadership of the organization and failed to do so. So we'll see whether the jury buys that. Now, I imagine, as you said, later this week, the jury will get the case and will begin its deliberations. And ultimately, the consequences could be fines for the Trump Organization. You know, when it's an entity as opposed to a person that is on trial in a criminal case, the entity can't go to prison. And so typically what happens is that entity is assessed fines. But usually it's the amount of the tax loss plus additional fines. The goal of a prosecution like this really is about deterrence, about letting people know that you have to play by the rules. And if you don't, there will be consequences.
I want to pivot, if we can, Barb, while I have you, to talk a little bit about the DOJ special counsel investigation of those Mar-a-Lago documents that, in fact, were seized. And what I found was interesting, I think a lot of us kind of saw this in our feeds over Thanksgiving, was Jack Smith issuing this letter, right, working on a Thanksgiving holiday, essentially to point out to the 11th Circuit Court of Appeals this inaccuracy he feels as if was laid out by the former president's attorneys. What does that signal to you about Jack Smith's role in this whole thing going forward?
Yeah, it seems like he has ramped up to speed very quickly. It does not seem like he's going to take, weeks and weeks to read everything and try to get up to speed. He is proactively involved in the case immediately. That is his reputation. And so I think that we're going to see not only no delay, but maybe even an acceleration. And although, I certainly was one who thought a special counsel wasn't needed in this case, I think it still may be something that is beneficial to the case. Because when you think about all of the things that Merrick Garland has on his plate, balancing, voting rights and violent crime and other threats to the American public, his ability to pay attention to this case is much more limited. For Jack Smith, he's got two cases, Mar-a-Lago and January 6th. That's all he has to worry about. And so because of that focus, I think we may see the case move even faster than it would have without a special counsel.
Let's talk about quickly the ask for former Vice President Mike Pence to testify for the grand jury. And I want to read for folks the tweet that you put out there. Questioning Pence is a no-brainer for DOJ. The step is essential to understanding what happened between him and Trump. Executive privilege will certainly be outweighed by the significant national interest in the attack on the Capitol. Subpoena away. We know that Pence has essentially said, and he said to my colleague, Chuck Todd, that he's weighing whether or not he's going to testify. We know he outright said no, moving on from the January 6th investigators asking for him to testify to their congressional investigation. What do you make of the possible testimony from the former vice president?
I think DOJ most certainly wants that testimony because we know from reporting there were instances when it was just Pence and Trump in the room talking about this plot to subvert the election. So Mike Pence is an essential witness that the Justice Department just needs to talk to. If he's helpful, he's an important witness. If he's not helpful, it's important to know that and lock in that testimony and understand what his understanding of the issues were. I imagine that he may assert executive privilege, but because it's only a qualified privilege, As we saw in the Nixon case, it may be overcome when there is a greater national interest. And the Supreme Court has already held that the January 6th investigation did outweigh executive privilege when it came to the production of White House documents by the National Archives to the committee. This idea of he's deciding whether he'll testify, I suppose is something that DOJ should explore. If he can come in voluntarily and maybe work out some parameters as to the topics and whether it'll be by video as opposed to making him actually show up to the grand jury, that's all fair. But at the end of the day, if he refuses to testify, DOJ has subpoena power and will compel his testimony.
Barbara McQuade, as always, we thank you.